colleagues, to start the second day of our workshop today, I would like to kindly invite Ms. Sandy Widjaja, Senior Legal Counsel from the IP Office of Singapore, to share with us about the operation of IP mediation in Singapore. Ms. Sandy joined the Intellectual Property Office of Singapore in 2009 and is currently serving as hearing officers, principal assistant registrar, and senior legal counsels. Prior to joining the Hearing and Mediation Department in 2009, Ms. Sandy was working at a state department in Western Australia for 2 years, dealing with legislation matters. Before that, Sandy will also work with IP Office of Singapore at the Registries of Trademarks, handling registration of trademarks and the implementation of the Madrid Protocol. Ms. Sandy has spoken at various events and seminars, both international and national, including at EU IP Case Law Conference in 2020, as well as the IP Academy of Singapore. Ms. Sandy holds a Bachelor of Laws from the National University of Singapore and a Master of Laws from the University of Western Australia. Ms. Sandy, thank you very much for joining us today. The floor is yours now.
Good afternoon, everyone. Thank you very much for having me. My name is Sandy. I'm the Senior Legal Counsel at the Hearings and Mediation Department from the Intellectual Property Office of Singapore. So today I hope to share with you our experiences and lessons that we have learned throughout the years in relation to IP mediation. This is the brief overview for today. First and foremost, if I may just clarify, the Hearings and Mediation Department, although the name has the word mediation in it, we do not conduct mediation. But what we do is we highly promote mediation. And in this regard, we work very closely with the local institutes of mediation in Singapore in relation to this. I believe the Singapore International Mediation Centre has shared their experiences in Workshop 1. So that SIMC for short is one of the institutes that we work closely with in order to promote mediation of IP disputes before IPOS. So I'll be sharing our experiences in relation to this from the IP Office perspective. First of all, if I may just briefly reiterate the benefits of mediation, the characteristics of mediation which render it very beneficial for IP disputes. As we all know, there are many different options for dispute resolution, and what I have here in the slide is a spectrum of dispute resolution options. For mediation, as you can see, it sits on the blue side right next to negotiation. The reason why it is next to negotiation is because it is very informal, which partly explains why it saves costs. And the next reason why it is next to negotiation is because while there is a third party involved, this third party can only facilitate and not determine the solution that is created during this process. So parties have a large control power over the solutions which are generated during the session. Also, it is confidential. Therefore, if parties wish to keep the sales figures as well as advertising figures confidential, mediation is the way to go. And thirdly, but definitely a very big factor, it saves cost and time. And that is partly because of the territorial nature of IP disputes. And I have concrete success cases later to share with you to demonstrate how useful it is a tool to save cost and time. And finally, but definitely not the least, mediation allows parties to preserve business relationships, which we all understand is very important, especially during this tough situation in COVID. This is a quote, if I may, that was given by our Chief Justice. It's some time back now, back in 2016, but which I think it is really still hit the nail on the head. And therefore, if you allow me to just read the quote in full, an ideal system of justice is one that delivers justice that is customized to each type of case, keeping in mind the subject matter, the parties, and the desired outcomes. In this regard, it would perhaps be timely to embrace a paradigm shift and understand ADR as a reference to, not to alternative dispute resolution, but as a reference to appropriate dispute resolution instead. So that was a quote by our Chief Justice Menon back in 2016. So what we want to emphasize is that mediation, even though it is an option under the alternative dispute resolution option, should not be considered as inferior to conventional dispute resolution, which is litigation. On the other hand, we are not advocating that mediation is superior to litigation. But what we are saying is that we have to find the most suitable dispute resolution option to resolve the IP dispute resolution at hand. At the end of the day, all the different options are just tools in a toolbox, which enlarge our choices to choose the best dispute resolution option in the best interest of the clients in the dispute. And in this case, in our experience, we have concrete case examples to show that mediation is very useful, very beneficial for IP disputes. In my example, it will be in relation to trademark disputes. So let me share with you now what our offerings are in relation to mediation. This is a process flow of one of our most common contentious proceedings before IPOS, and that is in relation to pre-grant or pre-registration certificate grant opposition of trademark process. As you can see, the two green arrows, we introduce mediation at two stages. First of all, at the arrow on the left-hand side at the case management conference. As the name suggests, it is a stage whereby the registrar tries to manage the cases before it. It is conducted at an early stage of the contentious proceedings, right after the pleadings close. And the reason why we introduce at this early stage is because at this point, after the pleadings close, parties have not yet expended any cost to draft their evidence. And therefore, if they can mediate right after this, they will save a lot of money. On the other hand, we also recognize that sometimes it may be easier for the parties to come to a decision whether or not to mediate. One, they have full sight as to the strength of their relative cases, and this can only be the case when parties have sight of each other's evidence. And therefore, we also introduce mediation at the late stage of the pre-hearing review stage, which is the arrow towards the right, at stage 9. This is the stage just before the full hearing. It is the stage where, in case parties decide to go to a full hearing, the registrar will ensure the case is ready for hearing. So parties can still consider the option of mediation at this late stage before setting the case down for hearing. And to make it clear that we are for mediation, even if a hearing date has been set down for a full hearing for the case, parties can still write into us to inform us that they wish to mediate. As long as the case has not been heard, they can still go for mediation. Therefore, as you can see, we weave in mediation into different stages of the contentious process before IPOS. Next, I want to share about what we do to help to encourage mediation, and that is funding. For several years now, we have this scheme called the Enhanced Mediation Promotion Scheme. And as you can see, it's basically funding 10,000 Sing dollars per case, which means if we split between two parties, it is Sing dollars 5,000 per party. If it involves only Singaporean IPs, and it can go up to 12,000 Sing dollars per mediation case. If you split between two parties, it's about Sing dollars 6,000 per party in the event that foreign IPs are involved. What we are saying is that we are so convinced about the positive effects of mediation, we want parties to try mediation on its own. So the whole objective behind this is to let parties try for themselves how useful it is to mediate a dispute, and therefore encourage a mindset change. So now we have several success cases, and if I may, I will just share our very first success case under this scheme. This is back in 2019. Both parties were foreign parties. They flew to Singapore for the mediation. One party is from the US and one party is from Thailand. And they resolved the dispute before IPOS and also achieved global resolution. So in total, 6 jurisdictions were involved. Definitely the US, and then Singapore, Thailand, Vietnam, Malaysia, and Indonesia. And all this was achieved in a total of 20 hours. You would appreciate that this is a very big difference. Instead of going to each jurisdiction, hiring a lawyer from each jurisdiction, which takes a lot of time, a lot of money, a lot of effort, and possibly some language issues. The total cost is Sing dollars about $11,400, and that is split between two parties. And in this case, because parties apply for funding under the scheme, the amount is fully subsidized under the scheme of 12,000 Sing dollars. In fact, there is some leftover money to partially defray mediation-related lawyer fees and disbursements. And we have very positive feedback from both parties. This is extracted from the feedback form that we received from the parties. The Thai party said that he's very glad that the mediation in Singapore has helped them resolve the existing dispute and achieve win-win for both parties. The US party said that the success of the mediation is very successful. Apart from settling the current dispute, they also ensured protection of the company's brand image, as well as the rapid development of their business in Southeast Asia. I have two other cases with me, but in light of the constrictions of time, I will not be sharing with you here. You can take your time to read the slides, which I will provide later to the organizers. I will just mention this. We have a compendium of successful mediation cases on our website, and these three cases are just some of the successful cases under the Enhanced Mediation Promotion Scheme. If you're interested, you are welcome to come and take a look at our compendium, which is provided under the link in the slide. Now, if I may just share some challenges and best practice which we have learned over the years by trying to promote mediation. First and foremost, there is an important need for mindset change. There is a need to emphasize to the parties that mediation is definitely not an inferior dispute resolution option to litigation. And it's also not a sign of weakness to agree to mediation rather than to go for litigation. In fact, it is a very beneficial move because mediation opens up to both parties a lot of different ways to resolve the dispute, and parties are free to consider business interests and not just the legal remedies that are available by proceeding with litigation. That is a general challenge that we need to overcome. Secondly, what we have learned from the specifics in terms of operation challenges. First and foremost, it is important to integrate the mediation process into the contentious proceeding so that the agents, the lawyers, are made to sit down formally and inform their client of the benefits of mediation and inform them of the availability of this option. Secondly, we also understand from the parties that it is useful for them to consider mediation at an early stage because, as I mentioned earlier, it does help to cut costs because parties have not made any expenses in order to file any evidence before us. But of course, as I mentioned earlier, depending on the case, sometimes parties may have to wait until the end, close to the full hearing where the evidence is filed before they understand the importance and relevance of mediation. Number three is funding. We noticed especially in Singapore, especially the smaller companies, the small and medium enterprises, they do need help in terms of funding to at least give mediation a try. And that's why we provided funding for the parties to try mediation a few years back. Last but certainly not least, because ADR options, including mediation, is consensual in nature, there is a need for both parties to consent. So there have been a few instances where one party wished to mediate, the other party does not wish to mediate. In relation to this, we understand that several mediation institutions have now a new service to allow parties to request for provide a unilateral request of mediation, and then they will provide the service to help persuade the other party to consent to mediation. So these are some of our sharings from some of the lessons that we have learned throughout these years. I hope you have found them useful, and I look forward to learning from you as well. Thank you very much.
Now we'll fly to Thailand to visit the Department of Intellectual Property to hear about the IP mediation service in Thailand. And for this topic, I would like to invite Mr. Phanuwat Kathong, legal officials, the head of Dispute Resolution Group from the Department of Intellectual Property Thailand to share with us about the operation of IP mediation in Thailand. Mr. Phanuwat Kathong has been working as legal officers at the Department of Intellectual Property Ministries of Commerce Thailand since 2003. Recently, he has been positioned as head of Dispute Resolution Group, being the Secretary of IP Alternative Dispute Resolution. He has been also the Secretary of the Trademark Appeal Board for almost 11 years. He also be the legal officers in the Legal Development Group for almost 3 years and legal officers in the IP Litigation Group for around 2 years. Mr. Phanuwat, we thank you very much for joining us today. The floor is yours now.
เริ่มนะครับคือกระบวนการไกล่เกลี่ยข้อพิพาทของกรมทรัพย์
With regarding to the mediation process and in IP process in Thailand, it is quite flexible, I can tell you. And we would like to offer the services regularly and in order to increase the rate of success to the parties. So basically for the IP ADR, we have seen that it is very essential. And since the IPR is part of the business, is part of commerce, and so we have seen increasing cases, and therefore in 2002, the DIP proposed for having the ADR process in place. So in order to increase the number of IP disputes into the process and also to support and reduce the number of cases in the court. And actually for the mediation, there was a rules of mediation in place. It is the MOC rules enacted in the 2002. And basically, there are prescriptions related to the different areas of services. But under this rule, the cases must be the IPR in nature. So the cases might related to the trademark infringement, or and for instance, and some unscrupulous persons might use the trademark, or for instance, the Facebook or other, and so there are prescriptions related to the appointment of mediators and or co-mediators. There might be the cases that require more than one mediator, and at the same time, under the rules of mediation, there are certain principles, for instance, on the confidentiality. But again, there are certain limitations. For instance, the content of the settlement can be disclosed in the case of further enforcement later on, and there are prescriptions related to the elements of the settlement agreement. And basically for the mediation services, actually it is free of charge, and the settlement can be the MOU or the settlement created from the both parties conference. Basically the mediation meeting can be the private court cases and the joint meeting. So but basically we have 3 types of mediation services. The first one is the face-to-face mediation. So we have the facilities and the DIP from the start to the settlement, the facilities we accommodate all kind of meetings, and so now for the face-to-face, it is good for like reduce the like drafting process and everything, because everything can be settled in the meeting rooms and in the same facility, so they don't have to send the documents back and forth and everything. But again, there are certain challenges for other parties who cannot present at the IP, and sometimes it is difficult to schedule for their availability, right? So we offer the second type of services. It is the online dispute solution. So we establish the Talk DD platform, and so the parties can like file their claim through their request for the mediation process through the online platform. And the advantages are that it is very fast, but again they need to have a secure internet connection, and there are certain limitations though. For instance, we need to rely on the email address, and for instance, the payment, the one party have to also identify the party and another party's email also in the system, so that we can like contact both parties. So it is required that both of the parties have to file, and sometimes they don't aware that they have to enter the relevant email and then they click submit, and sometimes they are afraid they wouldn't like to click submit in the system. And again, if they basically there will be a contact from the platform admin, and so they then both parties have to click the submit or accept to enter into the process. So after, in order to resolve those kind of challenges, we come up with the third type. So basically, the IP will like draft a letter and send to both parties, and we give them the choices for their meeting. For instance, if they would like to us to conduct the mediation through face-to-face or to Zoom or to Line or otherwise, and both parties at this point they can reply to the IP that for instance they can choose the platform on Talk DD. They would like to mediate through the Talk DD, and or we can like recommend both parties to go on the mediation process on the Talk DD platform. And basically, the DIP will set up the 3 conference rooms for like for a private caucus, for joint meeting, and for discuss with the mediations. But we also provide the option whether they would like to sign the drafted settlement at the DIP, or they can, each party, they can sign the settlement separately. But most of the time, we find the delay it is in the signing stage because we will send the drafted settlement agreement to each party, and most of the time they try to make a lot of correction at the later point, so they have to come back for discussion why they need require the correction to the settlement draft settlement. And again, sometimes it's difficult for different parties to agree at the first time what type of the services they would like to use, and sometimes certain parties they only try to delay the litigation process by apply the mediation services. They do not have the clear intention to end these problems. So this slide I show the meditators. We work as a team. So the first component the team of meditators there will be chairman. The chairman can be the director of relevant division or the IP expert. For the second element, it will be the legal officers, and the third one, there are experts. Those experts came from different divisions, probably from the trademark division or from the patent division, for instance, and they can provide the expert advice on the processes and regulations in different area. And the third component of the meditators team is secretary. They will support on the reporter and taking note and everything. So for role of meditators, basically the meditator will provide the information and on the laws and processes or legal facts. And second one, the meditator will support on finding the key issues or identifying the both parties' interests and try to find a way to resolve the issues. And the third role is to facilitate the meetings, the conference, right? For instance, the meditator will ask questions or will guide to the appropriate process. And the fourth one is we will support on drafting the settlement agreement, and the drafting will be according to both parties' requirements and interests, and both parties will review before they will sign off the settlement. So basically, we provide services since 2002, right? So if we look at the statistic up to 2021, so we have most of the cases from the trademark. For the Talk DD, we just start in January this year, and if you look at the chart, we have success rate like 4 cases of the ODR, but we have certain challenges to improve on encouragement for parties to use ODR. And for the conflicts, we have seen in 2021 we have seen more cases related to the copyrights, and so we have seen more cases related to the opposition of the trademark, and so we have a new processes to expedite the registration of the copyrights and trademarks. So we have seen more cases of opposition, and we have seen like for the one, you see the non-settlement. And many times the parties file for mediation, but they are not the IP cases. So we have to turn down those requests also. Because we need also check their business contract, whether there was a cost related to the ADR, and we have the ceiling from about 300,000 USD to million USD. So that's the kind of the claim, small claim that we can deal with. So basically, we have the two concepts of the ODR adoption. The first one, like I said, for the case study, the claimant party is a U.S. company, so they claim and they send their complaint to another party in Thailand. But the IP send the letter to the IP owner in the USA. They cannot like organize for the legal representative in Thailand. So this kind of case, there is difficulty that we cannot do anything, right? And for the second one, the claimant and they are in the like remote area and they cannot show up at the DIP. So the way to resolve the second case is to come up with the initiative. So we set up the smart DIP, and we also come up with the e-certificate data, and we're going to apply the big data by the input from the trademark database and other IP rights database. And that's about it. May I conclude my presentation here? Thank you.
Yes, thank you very much, Mr. Phanuwat Kathong, for sharing with us about the operations and challenges of IP mediation service in the IP Office of Thailand. For now, we will come to the Q&A session of our first topic. I would like to invite both Ms. Sandy and Mr. Phanuwat to join us for the Q&A session. In case you have any questions for our two distinguished speakers, you can either raise a hand or you can drop your questions in the chat box.
Yeah, actually, it's if I may, is it okay if I try to answer this question? In fact, one of my case studies is my third case study, which I didn't have time to go through. I think one of the beauty of mediation is you can choose the mediator. If you go to court, you cannot choose the judge. If you come for a hearing before us at IPOS, you cannot choose the hearing officer, but for the mediator, you can. And in the third case, in my slide, there was it concerns three related commercial entities based in Singapore, Malaysia, and Indonesia. And one of the key points which enabled the mediation to succeed is that the mediator was able to speak Bahasa Indonesia. And at one of the private caucus with the Indonesian party, she was able to use Bahasa Indonesia to build trust with the Indonesian party. So I think, yes, hopefully you'll be able to appoint someone who is well versed in more than one language, so that this person can effectively address the issues in both languages competently.
Yes, thank you very much for sharing with us, Sandy. I also would like to also ask Mr. Kun Phanuwat if you already also face this barrier in practice, and if you would like to also share with us.
ข้อพิพาทเข้ามาสู่กรมทรัพย์สินธรรมยาส่วนใหญ่จะ
most of the cases the parties are in Thailand, and so we haven't seen this kind of barrier yet.
Yes, thank you very much, Mr. Phanuwat. The second question for Sandy. What kind of disputes does IPOS mostly get to mediate?
Yes. Sorry, just now I realized my button was not off. I hope just now it came out English and fine. I'm so sorry. Okay, most of the disputes so far, the success cases we have heard so far is mostly in relation to trademarks. So that currently as it stands, although mediation is open to patents and other forms of IP disputes, so far the success cases has been mainly trademarks.
Thank you, Sandy. The next questions that we received for both of our speakers, Sandy and Kun Phanuwat. What have been the most challenging aspects of the mediation process for you and for your organization? And what is your approach to these problems? I would like to invite Sandy first to answer these questions.
Yeah, I think like I shared in my last slide, unfortunately, there's still a lot of misconception about mediation. What we understand is that people generally feel that it is inferior to litigation, which shouldn't be the case, really. And I think the focus that parties should have is to solve the issue at hand. It doesn't matter which route you use, whether it's arbitration or mediation or litigation, you should choose something which is appropriate to you. And to just make it clear, right? We also understand that there's certain trademark disputes which may not be suitable for mediation. But what we are saying is in most cases, mediation is very suitable. So for us, it's the mindset change that we need to overcome.
Yes, thank you, Sandy. We also would like to also invite Mr. Phanuwat if you would like to share some of your view.
คำท้าทายของผู้ให้เกียรติของผมก็คือว่า
For most challenges from the IP, so basically only one party requests to enter into the mediation process. But for another party to the dispute, and most of the time the IP have to convince them to take part. And another challenge is one of the party to the dispute, most of the time they come up with very high number, very high number of money they would like to request. Most of the time they come up with really huge amount of money all the time. So basically, and then they got their excuse. And they come up with the first question, what it takes for them to join the mediation process, and how will they get back.
I agree, Ms. Phanuwat. We also have this issue. That's also another of the challenges, to convince the other party of the benefits.